taking the appeal of Public Service Commercial Service Union against the Secretary of State of the Home Department and others.
Yes, Mr.
My Lords, my Ladies, I appear with Mr. Patel for the appellant, and my learned friends, Mr. Stillett's King's Counsel, Mr. Feeney, appear for the respondents. At page 264 of the bundle at paragraph 68 of his judgment, Lord Justice Lewis introduces his discussion of the claim under the 99 Act, saying, "The issue in this case involves the proper interpretation of Section 1 of the 99 Act." We respectfully agree. At the heart of this appeal, we say, are two related points of statutory construction. Section 1 of the Act is at page 500 of your bundle. Obviously, it appears in many places, but that's where the statute itself is excerpted. Subsection 1, subject to the provisions of this Act, the person who is not a party to a contract to third party may, in his own right, enforce a term of the contract if A, the contract expressly provides that he may. Now, pausing there, Section 1 explicitly then covers the situation where a term of the contract provides that the third party may enforce. Contrary, however, to what is repeatedly implied in the respondent's written case, Section 1 does not explicitly address the situation where the contract provides that the third party may not enforce. The effect of that, in practice very common contractual provision, is covered only implicitly by subsection 2, as we'll see. Then the other situation in which a third party may, in his own right, enforce is provided for at subsections 1b and 3, when it is presumed, subject to subsection 2, that the parties did intend third-party enforceability. Subsection 1b, if subject to subsection 2, the term purports to confer a benefit on him. So that's the first limb of the statutory presumption. Subsection 3, the third party must be expressly identified in the contract by name as a member of a class, etc. That's the second limb of the statutory presumption. Pausing again. It has long been properly conceded by the respondents that the check-off term does confer a benefit on PCS as a party identified in the contracts of employment. So both limbs of the statutory presumption are satisfied. So the parts of the respondent's written case which appear to, if not resile, at least seek to diminish the force of that concession, must, we say, be ignored. And in fact, the underlying dispute, the industrial dispute that brings these parties to court, arose precisely because the government wished to cease conferring that benefit on its recognised unions. If you go to page 382, it explains the position at the top of that page, which was part of a set of documents sent out in 2014 when the decision to recommend the removal of check-off was taken. Many departments provide a service to certain trade unions whereby subscriptions are deducted directly, etc. This is known as check-off. That was how it was viewed. Departments were providing a service to trade unions. And the previous page, 381, in the second paragraph, the change of policy is set out. It was no longer considered desirable for government employers to provide that service to unions and their members. Note, neither document refers to the provision of a facility to employees in the civil service. Returning then to the statute at page 500, and the way in which that presumption of an intention of third-party enforceability might be rebutted, subsection 2. Subsection 1b does not apply if, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party. That is the provision, the construction of which is at the heart of this appeal. Now, the respondents, like the majority of the Court of Appeals, say that they are applying those words, but they are not. And we say they cannot help giving themselves away.
382 you took us to a moment ago, is that a Cabinet Office document?
Sorry, my lord, is that a...
You took us...
Yes, it is. It is.
I suppose we should be grateful that they respect statutory obligations, apparently.
So the respondents proceed on the erroneous premise, I quote from their written case at paragraph 11, subparagraph 1, that the inquiry under subsection 2 arises ex hypothesi where the question of third-party enforceability has not been dealt with expressly in the contract. Now, that's just plain wrong. By far the most common circumstance in which subsection 2 applies will be, it is in practice, when the contract expressly provides that its terms are not intended to be enforceable by the third party. We've doubtless all of us seen such clauses in insurance contracts and the like. And all members of the Court of Appeal, by the way, agreed on that point. I won't take you to it, but Lord Justice Lewis, for instance, at paragraph 77 of his judgment said, if the contract expressly provided that the term was not intended to be enforceable, that would provide a clear answer to the question posed in subsections 1(1)b and subsection 2. Returning to the words, if on a proper construction of the contract it appears that the parties did not intend the term to be enforceable by the third party. There are two aspects to that provision, both of which have been misread or misunderstood, we say, by the respondents and by the majority in the Court of Appeal. The first is that for subsection 2 to have effect, the contract must show that the parties had an intention that the term should not be enforceable by the third party. And that is obviously a quite different requirement from it not appearing from the contract that the parties did intend the term to be enforceable by the third party. The latter will often be true in situations where the actual statutory test is not met. That is to say, the exception in subsection 2. And it's regarding this misreading of the statute that I say the respondents could not help giving the game away. If you go to page 197, the first example is as early as paragraph 3 of their written case, where they sum up the decision of the majority of the Court of Appeal in these terms. The majority rejected the appellant's claim on the basis that it did not appear on a proper construction of the employee's contracts of employment that the parties had intended that the term providing for the check-off should have been enforceable by the appellant. Now, in fact, the respondents perhaps can be forgiven at this point because it could be argued they are simply reflecting the error made by the majority in the Court of Appeal. But what is written further down the page in paragraph 4, subparagraph 3, can only charitably be characterised as a Freudian slip. If one goes, I'm sorry to jump around, we'll come back to that 4.3, but if one goes first to page 15, the court will see what ground 3 of this appeal says. The majority erred in any event, that is, even applying the wrong statutory test, in finding that on a proper construction of the employment contracts between the respondents and their employees, it appeared that those parties did not intend that the employee's contractual right to require their employers to pay their monthly subscriptions to PCS by check-off should be enforceable. That obviously quotes the statutory language. Going back, though, to page 197, subparagraph 3 of paragraph 4, That ground is summarised as being the Court of Appeal erred in determining that on a proper construction of the contracts, the parties did not appear to have intended that the check-off term could be enforced by the appellant, which, of course, is not the statutory test. Now, that error is not confined to misunderstanding the grounds of appeal. It informs the entirety of the respondent's submissions. If one goes to page 213, paragraph 56 of their written case, it is said that the test in subsection 2, which they are there referring to as stage 3, end of the fourth line, requires the court to ask itself whether or not the parties appear to have intended that the term be enforceable by the third party. Now, that would be true if the statutory language had been, if it does not appear from the contractual terms that the parties did intend the term to be enforceable by the third party. However, given the actual statutory language, stage 3 does not require the court to ask whether or not the parties appear to have intended that the term be enforceable, but rather to ask whether it appears from the contract that the parties did not intend that it be enforceable by the third party. If it does so appear, subsection 2 applies, and subsection 1 therefore does not. But if it does not so appear, subsection 2 does not apply, and therefore subsection 1 does. On the respondent's recast statutory test, there is no rebuttable presumption. In fact, there's no presumption at all. Now, just after the Law Commission report from which these words were ultimately taken was published, my Lord, writing as Professor Burrows, wrote an academic paper at page 904. And at the bottom of that page, one sees that, final couple of lines, the central aim of the paper was to explain the main features of the reform proposed in the report. And then at page 910 within the same paper, on the question before this court, in the middle of the page, there's a line beginning party full stop, and then the sentence begins, although this was not spelt out. It's that sentence I'm about to read.
Sorry, which page?
910, my lady. So it's a page that begins with the words on existing tests.
Yes.
There's a big paragraph in the middle, and halfway down that paragraph, you'll see a line beginning party full stop, and then the words, although this was not spelt out in the report. Does my lady have that?
Yes.
Although this was not spelt out in the report, it is my view that that presumption is a strong one. I would anticipate that it would not normally be rebutted unless there is a term in the contract expressly negating the third party's legal rights, or an express term that is otherwise inconsistent with the third party having legal rights. Put another way, as it was 4 years later in a later article written by Professor Burrows at page 928. In the third paragraph, after the reference to the New Zealand Contracts Privity Act 1982, a couple of lines down, there's a sentence beginning in the middle of the line, the presumption is based. The presumption is based on the idea that if you ask yourself, when is it that parties are likely to have intended to confer rights on a third party to enforce a term, albeit they've not expressly conferred that right? The answer will be where the term purports to confer a benefit on an expressly identified third party. That sets up the presumption. But the presumption can be rebutted if, as a matter of ordinary contractual interpretation, there is something else indicating that the parties did not intend such a right to be given.
Clearly, the something else relied on in this case is the context of the collective agreement.
to be fair to the majority of the Court of Appeal, I think there are 3 matters on which they base their conclusion, but none of them is one, as we will develop in respect of the second aspect of section 2.
You're saying it's not simply the presumption arises out of nothing, it arises from the satisfying of the first 2 limbs. A, that there is a term which purports to confer a benefit on a named person.
Precisely.
Yes.
And I don't know whether that is disputed, but as I will be saying, if it's accepted, the acceptance by the respondents is very sub silentio. But just to finish, if I may, although I'll be foreshadowing submissions I'm going to be making later this morning, an answer to my Lord Reid. Yes, the majority in the Court of Appeal do rely on that and 2 other matters, but none of those matters, we say, were properly relied upon as a matter of ordinary contractual interpretation, which is the phrase used in this particular paragraph. Going back to the respondent's written case at page 217, a concept is introduced which needs to be treated carefully. At paragraph 71, subsection 1, the respondent seems to suggest almost the reverse presumption to that created by the statute, though it is fair to say in the following paragraphs they do go back from that. Subparagraph 1, the second limb of section 1 of the Act is intended as a modified version of the dual intention test, whereby a third party may enforce a contract in which the parties intend that he should receive the benefit of the promised performance, so that's the confer a benefit point, and also intend to create a legal obligation enforceable by him. Now, as I say, one needs to treat that with some care, because the dual intention test, which is correctly explained by my learned friends in the sentence I just read out, had been initially proposed prior to the Law Commission consultation process, but was replaced in the Law Commission report and then the statute by something which, once those important indications of intention in subsections 1b and subsection 3 are met, is in fact closer to the opposite of the dual intention test. Namely, that the third party can enforce even though the contracting parties did not intend to create that legal obligation, unless the contract makes it clear that they did not so intend. So too, if one goes to page 222, at the bottom of that page, within paragraph 85, subparagraph 2, in effect quoting from part of the judgment of Lord Justice Lewis, the respondents say this: the ultimate question is whether the parties intended that the term should be enforceable by the third party. Again, the statutory question under subsection 2 is a different one: whether the terms of the contract show, if the qualifying criteria are met, that the parties did not intend the third party to be able to enforce. In addressing that question, the respondent's following comment that the burden of proof is rarely likely to be determinative is probably right.
Sorry, you say it's right?
I think if you are addressing the question that they pose, which is the wrong question, then I think they are right to say that it will rarely turn on the burden of proof. However, and this is the nub of it, the answer to the statutory question will often turn on it not being possible to construe the contract so as to conclude that the parties had that negative intention, not being possible, in other words, to rebut the statutory presumption. Over the page at subparagraph 3, so the next subparagraph, the respondent suggests that it is inherent in the terms of 1(1)(b) and 1(2) that the court may need to seek to determine the intention of the parties in circumstances where the contract does not expressly state whether the term should be enforceable by the third party. We accept that it may in theory be possible to construe certain contractual terms as negativing an intention of third-party enforceability without those terms expressly so providing. In theory, we accept that is possible, though the respondents give no example and the case law has not yet provided one. Although even that is not inherent in the statutory language, but that's a very different matter from the respondent's case that the court needs to determine as a matter of objective fact the intention of the parties in circumstances where the contract is silent on the point. Far from that being inherent in subsection 2, that proposition would cut right across the statutory presumption. But that is the respondent's case, revealed most clearly at paragraph 88 down the page. The final two sentences forgive me. No, let me read from earlier in the paragraph. Second line. In our case, its case, it appears to come close to submitting that where the contract is silent on whether it was intended that the third party should be able to enforce the term, the effect of the rebuttable presumption is that the court must find that it was intended that the party should have that benefit. Third party, should have that benefit. But, they say, that would be to rob section 1(2) of any content. The section only comes into play where the contract is silent on third-party enforceability. Now, when they say we come close to submitting that, that is exactly what we submit. That's what subsection 2 provides, that if on a proper construction of the contract it does not appear that the parties did not intend the term to be enforceable by the third party, it is enforceable by the third party. However, and this is the important point to make by reference to that submission, that approach does not rob section 1(2) of any content. On the contrary, subsection 2 is regularly, in practice, determinative, where, despite conferring a benefit on an identified third party, the contractual terms make it clear that the parties do not intend that there should be third-party enforceability. If it hadn't been for the qualification in subsection 2, then provided the term of the contract conferred a benefit on an identified third party, the third party would always be able to enforce it. That is its content. And reading on in paragraph 88, the respondents say...
So you say the content of section 1(2) is actually to allow parties to contract out of these...
Absolutely.
Expressly contract out of these rights.
Well, I don't...
You don't say it's only that, but you say that is its content.
Well, what I would say, my lady, is it allows the parties to contract out, and they will almost always do so expressly. But I accept that it may be possible that you have a term or terms of the contract which, applying the proper principles of contractual interpretation, should be construed as negativing third-party enforceability, even though the words on the page do not say we negative third-party enforceability or we do not wish to the Contract Rights of Third Parties Act 1999 to apply.
That's what Professor Burrows, as he then was, meant in the first, perhaps in the first
I'll come back to that
about...
quote, my lady, when we discuss what proper construction of the contract means, but that's certainly our case as to what he meant. But I always, I've long felt that I may have to adopt a fairly embarrassing position of asking someone to accept my submission, what they meant when they wrote something. But that is going to be my diffident submission as to what he meant, yes. If one goes then to the final sentences of paragraph 88, the respondent there says, the section comes into play only when the contract is silent on third-party enforceability, requiring in those circumstances the court to ascertain, for which we say effect or construct the intention of the parties by reference to the relevant background and factual matrix. Now, obviously on its face, that's manifestly wrong. It is, and it is only where the contract provides that there should not be third-party enforceability, whether expressly or as a matter of clear implication, that subsection 2 comes into play. Where the contract is silent, where it does not, to quote the statute, appear on a proper construction of the contract that the parties did not intend the term to be enforceable by the third party, then, again, providing the qualifying criteria are met, the subsection does not apply. The majority in the Court of Appeal adopted exactly that same misinterpretation. They asked themselves the wrong question. Instead of asking the question posed by subsection 2, whether the terms of the contract showed that the parties did not intend the check-off term was enforceable by PCS, they in effect asked themselves the question, assuming the parties had a joint intention that the check-off term should or should not be enforceable by PCS, what was that intention? Let us look at the background facts, not the terms of the contract, but the background facts, and we say construct or effect it. We say, and this is ground 3, that even that question as posed elicited from them the wrong answer, but that is not the primary error. Going to their judgments, at page 266, we say that Lord Justice Lewis led himself astray immediately within paragraph 71. He refers there to the Law Commission having proposed a dual intention test and then quotes from the report, a third party may enforce a contract in which the parties intend he should receive the benefit of the proposed performance and also intend to create a legal obligation enforceable by him. However, he doesn't say that that test had only been proposed at an earlier stage, pre-consultation, and was rejected following consultation. That of itself, that might be seen only as an unfortunate ambiguity. But it's that in combination with the first words of paragraph 72 that is problematic. And that paragraph, by the way, 72, is cited within the judgment of the Lord Justice Underhill with approval. Because the final proposals of the Law Commission, which were adopted as Section 1 of the Act, were not the way in which that test, the dual intention test, was to be achieved. Rather, the final proposals, the statutory words, constituted a significant change to that test. So it's perhaps not surprising that Lord Justice Lewis goes on to interpret subsection 2 as in effect providing for a dual intention test. If one turns over the page...
Do you know whether in the original consultation paper those first two limbs, the term purporting to confer a benefit and the naming of the third party, were those proposed or did those come in only at the report stage?
The short answer is I do not know. The longer answer is the way I read the report, they came in at the report stage because, as we'll see, the report sets out and then considers the tests and what the consultees had said about the tests and why, on reflection, it may not be the right phrase, but something like on reflection, they considered the dual intention test was too uncertain and therefore proposed this new test. So it wasn't, as I remember it, but we'll have a look in a moment, part of any of the original 6 tests. It certainly wasn't the substance of any of the original 6 tests. So if we go over the page to paragraph 75, that's another paragraph that Lord Justice Underhill, in his judgment, cited with approval. We say Lord Justice Lewis redrafts the statutory question in the same terms as the respondents seek to uphold, namely, in the second and third lines, to determine whether the parties to a contract intended that a contractual term should be enforceable by a third party, which of course would be the right question if the dual intention test had been enacted, but it is the wrong question given the actual terms of subsection 2. And that's why at the end of that paragraph, Lord Justice Lewis in effect jettisons the rebuttable presumption provided for by the statute.
Can I just come back to what you said about Lord Justice Underhill and his approval of what was said by Lord Justice Lewis? At paragraph 117...
That's the one I had in mind, yeah.
Yeah. Lord Justice Underhill is, I think, saying, well, the test set out, see paragraph 72 of Lord Justice Lewis's judgment, and then I agree with his observation about the generality of cases, but that is not necessary to my reasoning in this case. So he's clearly not deciding the case on any sort of misunderstanding, as you would put it, of the intention test, as I read it.
I think that is probably fair. I mean, I had read, so for those who aren't on page 278, my Lord is reading from page 278, paragraph 117, within Lord Justice Underhill's judgment, and it's the last 4 lines of that paragraph. The way I had read it is that he agrees with the observation that in the generality of cases, the court is likely to be able to reach a conclusion one way or the other about the party's intentions, as necessarily agreeing the reason Lord Justice Lewis gives why that should be so, because if one applies, as we say, the statute as it should be applied, there's no question about the court being likely to be able to reach a conclusion one way or the other about the party's intentions. The question is, are the two, assuming there's no express term saying that it should be enforceable, are the 2 qualifying criteria of 11B and subsection 3 met? If so, does the contract provide that the parties did not intend it to be enforceable? And it's a binary question, whereas...
Well, only where it's express, where you've got to construe the other terms, then you need to look to see what evidence there is to support a conclusion that by implication the parties have, it appears that they didn't intend, and there the burden of proof may well come in.
Well, I suppose, I mean, I'm going to focus more on the words on the proper construction of the contract shortly, but I entirely agree with my lady that if one is talking about the construction of contractual terms, so the words on the page say this, I say they mean one thing, and if friend Mr. Stillett says they mean a different thing, and the court has to decide which of us is right, then, and I'll come to all the case law on this very briefly, I hope, then of course there will be circumstances in which it would be entirely legitimate to look at some of the background circumstances to decide which of us is right. And although I really have struggled and found myself incapable of actually coming up with a hypothetical example, but let us accept that in theory there may be one. You could have 1 or 2 contractual terms where I am saying, members of the court, look at these words on the page, they do not negative an intention of third-party enforceability. And my learned friend is saying, look at the same words on the page, they do negative an intention of third-party enforceability, and he relies, in support of that submission, on some of the background, the factual matrix, the background facts, as making his construction of the contractual term or terms more likely to be correct. That situation, of course, can arise. As I say, I've really struggled without success to come up with a term or terms where that exercise would legitimately be undertaken, but I accept it could be. That's not this case. What that is very different from, and I will be developing this at greater length, I'm afraid, because ultimately this case really turns on two short points. But what that does not permit is for the parties to look at a contract that says absolutely nothing on any view about third-party enforceability, and in respect of which there is no dispute as to the meaning of any contractual term, and then say, as this majority of the Court of Appeal said, all right, we've still got to decide, did the parties intend that this term, this check-off term, should be enforceable by PCS? Okay, there's nothing in the contract. We're not going to invoke the statutory presumption. We're just going to, as it were, do a deep dive, look at what happened, or at least what we think happened in 1960, look at the terms of the contract, and we're going to decide that, presumably on the balance of probabilities, insofar as they had any intention, it was that it should not be enforceable. That exercise...
So is that the difference between your ground 2 and your ground 3, basically?
The difference between my ground 1 and my ground 2, I would say. But ground... well, I don't know. I mean, ground 2 focuses on that distinction between what we say is the legitimate exercise of contractual construction and the illegitimate.
And that is that you can look at the background circumstances if there's some wording which is ambiguous. But here you say there's no wording at all, ambiguous or not, it just is completely silent about it. Nor is it possible to look at a different contractual clause and say that is inconsistent with the grant of third-party rights. And in those situations, you say you're just left with the presumption.
My lady puts it better than I just have, yes. And moreover, that is exactly the situation that the Court of Appeal has twice, not in this case, but has twice already had to contend with, as it were, and also in a third case, the High Court. So there were 3 cases, we'll come to them, where Section 1 has come before the court, 2 that went up to the Court of Appeal. In none of those 3 cases did the contract say anything about third-party enforceability. It was, to use the apt metaphor of my learned friends, silent on the point. And the courts, therefore, did apply the statute and determined that, yes, Section 11B was met, yes, subsection 3 was met. The presumption, therefore, existed. It had not been rebutted.
So can I just understand your reply to my lady? Are you suggesting that in this case we cannot look at the context? Are you saying that there's an ambiguity hurdle that first has to be overcome before one can look at the context in deciding whether the parties did not appear to have intended to have conferred the third-party right?
I mean, whether I would characterise it as the shorthand an ambiguity hurdle, but effectively and in substance, yes. It's on a proper construction of the contract.
But we know that on a proper construction of the contract, almost you start with the words, admittedly, but you also look at the context. So it would seem, on the face of it, you know, there used to be a law that when you construe a contract, you have to first of all overcome an ambiguity hurdle, and that's long since gone. Are you suggesting that it's being reinvented?
Well, that's why I was a little reluctant to use the phrase ambiguity hurdle. What I say is that if there is a dispute, we've got, fortunately, set out in the judgment of Lord Justice Lewis and in your authorities part of this bundle all the most recent cases on the proper interpretation of contracts and the right way to approach that task and the principles that we must and must not be deploying, as it were. But if, to quote one of those cases, there are rival constructions. Now, whether that's ambiguity, I suppose it could be in the sense that you could just have a word that could mean one thing or could mean another, or it could be something a little less specific than that. But where there are rival constructions as to any term of a written contract, then, of course, my lord, I agree that the courts are not only able but required to take into account, albeit a relatively limited category of background factual circumstance.
I don't know why you say limited, but anyway, I mean...
Well, sorry, what I meant by that
I think Lord Hoffman would say anything that's relevant.
Yeah.
Well, yes, but he went on to say that does not include in the following subparagraphs, for instance, the subjective intentions of the parties, to take the most obvious example.
Or pre-contract negotiations.
That was also what I was... So the passage that we all have in mind says, yes, but I really do not conceive there to be any dispute between the parties, or hopefully between either of the parties and the court, as to what the proper principles of interpreting contracts are.
But you're accepting that the ordinary principles apply, and as my lord has put to you, that the investors' compensation scheme principles do apply in relation to construing these contracts in just the ordinary way?
Yes. Yeah. I mean, there's obviously been an arc of case law that, as Lord Justice Underhill points out, for present purposes probably ends with wood and capita, but and they all might be said, and commentators have suggested, say slightly different things, perhaps, but they all have this in common, that where you have written contracts, the parties are deemed to have included their contractual promises in the written document, and the question therefore is, what does that written document mean?
Well, but you've got implied terms as well.
Absolutely, my lady, and that is something that came up in the Court of Appeal, and my Lord Justice Stuart Smith asked my learned friend at the time, Mr. Sheldon, King's Counsel, you've never suggested that we should imply any term into this contract on the normal principles of business necessity, etc., etc. And the answer was no. And it has never been suggested, and it is not now suggested by my learned friends today, that there is any basis on which a term may be implied. But again, I entirely agree with the premise of principle, which is that if, on the normal basis, it is appropriate to imply a term which negatives third-party contractual enforceability, that would also qualify within subsection 2 of section 1 of the 99 Act. So there are, as it were, 2 or 3 gateways through which the promissor can seek to pass in order to take the benefit of subsection 2. The most obvious, they can write into the contract, third-party enforceability doesn't apply. Secondly, though, as I say, I found it hard to draft such clauses, they could write terms which, at least as found by the court, even if not obvious to the reader, have the effect of negativing without expressly saying so. And thirdly, if the relevant tests for implying a term are met, a term could be implied, which would still be a term of the contract, to negative third-party enforceability.
So just to be clear, are you accepting or not accepting that where the contract is silent about third-party enforceability, these principles are in play and the court can look at the proper construction of the contract against its background and context? so far as relevant.
Well, my lady, I don't want to be difficult, but it seemed to me that question almost implicitly defined silent in a way that I was not using the word. So if the contract is silent in the way I'm using that metaphor, namely the express terms and any implied terms say nothing about the question of third-party enforceability, then subsection 2 does not apply. That is what I am saying.
But that must be too wide range. That must be too wide a proposition. I mean, for example, within the Law Commission report, you'll find quite a lot of reference to the construction industry chain of contracts situation. Now, that is a situation in which there is nothing said expressly, one way or the other, about whether a third party should have a right of enforceability. But at least the Law Commission was taking the view that the context in which that third party right question would arise, that is a chain of contracts, that chain of contracts known to the parties negatives the intention. Now, on the proposition you've just put forward, that would be an impossible approach.
Well, respectfully, I don't agree, because I agree with the Law Commission report that that would be a situation in which third-party enforceability would not apply. The reason it would not apply is because it would be necessary to imply, on the basis of business efficacy, a term that each contracting party is only liable to the next party in the chain. And that's certainly how I have read and understood the basis on which the Law Commission report says that situation does fall.
Those contracts would work whether he had third-party rights or not. It's nothing to do with whether it's got business efficacy. It's just it's the context that people know that they're contracting against a background. And I think the argument that I'm coming back to the point that Lord Justice Underhill, which is where we started off this at the end of paragraph 117, says it was not necessary to my reasoning in this case. That's what I was drawing to your attention. What was decisive for him was what we're now talking about, which is the factual, or you might call it the legal matrix, which he thought was decisive. And I'm putting to you that the analogy is with the construction contract situation, a chain of contracts. Nobody says anything one way or the other about third-party rights, but in that context, if we've got a purported benefit conferred on an expressly identified third party, the intention is negative because of the background against which everybody's operating.
Well, I can only repeat that I would say that in that situation it would be right on applying normal contractual principles to imply a term to that effect.
And why do you say you would imply a term there?
Because in order to give business efficacy to that contract as part of the chain of contracts, the, as it were, chain of liability only has business efficacy if each contracting party is only liable to the immediately superior contracting party. But, my lord, if it is right that in a particular situation the border between an implied term and a clearly identifiable intention might be grey, we still say this case is not anywhere close to that grey area. But
I think your main submission is that the Arnold and Britton cases, they are relevant where there is an ambiguous contractual clause which might or might not be construed to negative the intention. But here nobody's pointing at some other term of the contract of employment to say that negatives the intention. There really is nothing. There's no provision made in the agreement for whether third-party rights arise or not. And I think your case is then you do fall back on the presumption because Section 1(2) is not satisfied and the criteria are there.
And that's what that's
and
right.
I think you say there's no then next step to say, is there anything around and about that could negative that presumption?
That's right, and that's what I meant when I was answering my Lady Simmons' question about silence. Where, if the contract is silent in that sense, then yes. What you'll see when we look at the cases, including this case, by the way, and other Chekhov cases, but also the non-Chekhov cases, you often see the words, there is nothing in the letter of instruction, letter of intent, nothing in the contract that negatives the intention. If there is nothing in the contract, then we say that is the end of the inquiry. And perhaps that's better than silence, which is a potentially ambiguous metaphor. But finally, and this is the very position I hoped I would never find myself in, of suggesting to my Lord Burrows that words in the report may not mean what he's suggesting to me they might mean. But we do say, we will be saying, that the statutory words on a proper construction of the contract are to be given their full force, and perhaps, if my Lord Burrows is right about the rationale for the chain of contracts case, greater force than had been appreciated at the drafting stage. But
at some stage, I hope you'll address Lord Justice Underhill's argument, really, that because by statute the collective agreement is not legally enforceable, therefore the parties to the employment contract can't have intended the check-off provision to be enforceable by the union.
of course, my Lord, that's our ground 3. In other words, they gave the wrong answer to the wrong question. But I do maintain that, notwithstanding the questions that have been put by both my Lord Reid and my Lord Burrows, we shouldn't get to that point, in this case at least. But yes, my Lord, I will address that.
In a way of putting it, just within the analysis that you're presenting to us, is that if you've got a context which both parties are aware of, it may not be business efficacy, but it might be, might it not, the officious bystander test. Because they might say, well, of course the parties wouldn't have intended this to be enforceable, because everybody in this context knows that this is the way things operate. Chains of contracts, everybody operates on the basis that each party can sue just up the line and no further. So if you were applying an implied term type analysis, although actually I'm not sure that you should be doing, but if you were, I would have thought the officious bystander might be a more appropriate question rather than business efficacy.
My Lord, I can see that in that case that would be right.
Although you then get into your problem that if you'd asked that question at the time, there were no third-party rights. So.
Well, there are so many difficulties in the way of coming up with the answer that the majority of the Court of Appeal did to that question in this case. But at the moment, dealing with the point my Lord raises of principle, I accept, again, yes, if it is possible to imply a term into the contract on the officious bystander test, that is no less a term of the contract than one that has been written down, and therefore is just as apt to meet the subsection 2 exception.
I wonder whether, in addition to your 2 limbs, that the contract purports to confer a benefit, that the third party is named, There's also, I noticed that in section 10 of the Act, as to where it comes into effect, it only applies to contracts entered into at the end of a period of 6 months beginning with the commencement of the Act. So a kind of a third limb, in a way, creating the presumption is that it doesn't apply to contracts which were concluded before the Act came into force, and everybody's got 6 months to sort out their contracts to exclude it if they want to.
My lady, that is very much part of our answer in respect to ground 3, and it's certainly one of the factors that Lord Justice Stuart Smith had in mind. But I would be getting ahead of myself as I develop that further at this point. So, drawing the threads of where I believe we are, it is important to acknowledge that the Act does not provide for that dual intention test, and therefore it follows that in most, we say probably almost all cases where the parties have conferred a benefit on an identified third party, but do not expressly provide for the material term not to be enforceable by him, then subsection 2 will be determinative. The rebuttable presumption will not have been rebutted. Because, and this is, if we step back, as it were, from these nice analyses of contractual wording for a moment, this is because in such cases, the parties, certainly insofar as the proper construction of the contract is concerned, but also very likely in fact, will have no subjective or objective joint intention as to third-party enforceability, or they may have subjectively or objectively different intentions. And that was the situation in the cases which have so far come before the courts, and we say it's obviously the situation in this case, bearing in mind, I suppose, 2 useful factors, one of which my lady's already alluded to. The first is that one of the parties to that contract, the employer, didn't believe that the term was contractual. That was its stance throughout this litigation until it was no longer able to appeal that issue. And secondly, my lady's point, where it did transpire that the Chekhov term was a contractual term of the relevant employment contract made after, or to use the statutory language, entered into after the 1st of May 2000, that term had been reproduced from a period when contractual third-party enforceability was an impossibility. So to ask oneself the question, what did they intend in terms of third-party contractual enforceability before the 1st of May 2000 is almost, well, I won't give obvious analogies, it makes little sense. And at no point in the judgments of the majority do they refer to, let alone accept, that in most cases the contract is silent on the question. It will be impossible on a proper construction of the contract to decide that the parties did or did not have a joint intention as to third-party enforceability. And it's important to recognise, we say, that this was a very large part of the reason why the dual intention test was rejected in the Law Commission report in favour of the actual statutory test, because one of the key threads running through the Law Commission report is the need to avoid uncertainty. So if we go to page 986, within, excuse me, within the Law Commission report at paragraph 1.7, at the very bottom of the page, speaking about the dual intention test and criticisms of it, at the very bottom of the page, the Law Commission report says this: thirdly, the existing legal regime, whilst complicated, achieved certainty. and reform would only result in uncertainty and litigation. So there were people who were saying, please leave well alone. We all know where we stand at the moment. If you adopt this proposed legislation, then it will lead to uncertainty and litigation. And in the middle of paragraph 1.8, nevertheless, the responses of the minority who opposed the proposed reform was invaluable in requiring us to reassess whether our proposals were too uncertain. In certain respects, and especially as regards the test of enforceability, we've modified our provisional recommendation in an attempt to allay those kinds of fears. And then at page 991, at paragraph 3.6, there's a heading, Complexity, Artificiality and Uncertainty. And, excuse me, this is under the general heading of Arguments for Reform. And the authors here turn the tables, as it were, and in the final half of that paragraph, they point out that the status quo, so before the legislation, was in fact leading to uncertainty, which they characterised as being commercially inconvenient. However, the key part of the report is part 7, which begins at page 1013. I hope now I'm going to be able to answer that question that was put earlier about whether the words confer a benefit appear as part of the test. And I was wrong, in fact. So if you have a look at the paragraph at the top, there's an introductory paragraph, and then it says the consultation paper set out 6 possible tests. These were as follows. And the first, in fact, does say a third party may enforce a contract which expressly in its terms purports to confer a benefit directly on him. And in fact, remember those words, because there's a reference, I hadn't realised or hadn't remembered it was a reference to that original number 1 test, as it were, but there's a reference to that, which we'll come to later. And at 3, you'll see the dual intention test, which I won't read out again because I've read it out before. And over the page, at paragraph 7.3, they deal with that dual intention test, which they say drew the most comments. And they say the majority accepted the test without criticism, but a substantial minority feared that that proposed dual intention test would lead to uncertainty in the law. And then at paragraph 7.5, I'm asked to read 7.4. We continue to believe, along with the majority of the consultees, that of the options set out, the dual intention test is the best approach. But we also consider, so whilst we continue to believe, we also consider, in the light of the views of some consultees, it requires modification and clarification in order to provide an acceptable statutory test. This is for 2 main reasons. In paragraph 7.5, third line, end of third line. Secondly, we agree with the strong view of many consultees that a test of effecting the party's intentions in light of the contract and surrounding circumstances produces unacceptable uncertainty. I'm going to read those words again because we say they are the complete answer to the respondent's case and the judgments of the Court of Appeal. We agree that a test of effecting the party's intentions in light of the contract and the surrounding circumstances produces unacceptable uncertainty. And the use of the word effect, we say, is apposite. Effect as in to bring about. And that is the task that Lord Justice Lewis and Lord Justice Underhill set themselves.
Well, if you read on the next sentence.
Yes, my Lord.
You just read them out.
In other words, while we continue to believe that one must seek to effect the party's intentions to confer legal rights on the third party, we consider that to avoid unacceptable uncertainty, one needs a clearer and sharper test for implementing that policy. We have therefore ultimately opted for a test of enforceability which, like the recommendations of the committee, emphasises the express terms of the contract, but also follows the New Zealand Act in relying on a rebuttable presumption of an intention to confer legal rights. I was going to read those words out in a moment, my Lord. So we very much rely on those words as well as the ones that I read out. We say that the distinction is drawn between, on the one hand, you have a written contract, you take into account whatever implied terms you need to take into account, you resolve any disputes on construction or interpretation that need to be resolved. And having done all of that, if the contract provides to confer a benefit on an identified third party and says nothing about enforceability, then that term is enforceable by the third party.
And we say they're contrasting two situations, one where the contract is completely silent and then you have to effect the party's intention by looking at all sorts of surrounding circumstances, and who knows where that will lead. And in order to avoid that, they say, well, if it's silent in the sense that you've been using that term, then what you do is apply a presumption rather than cast around for surrounding circumstances from which you try and divine an unexpressed and unimplyable obligation.
My Lady, yes. And in fact, this case is a paradigm example of what the Law Commission report says they were seeking to avoid, because by trying to effect the party's intentions in the light of the contract and surrounding circumstance, which was in this case impossible, the predictable result was that it produced wholly unacceptable uncertainty, with two judges saying they were able to infer a joint intention against enforceability by PCS, and four judges saying that they were not able to infer that joint intention based on precisely the same factual material. That's important. We'll come to that in ground three. Nothing new was presented to the Court of Appeal by way of fact or argument on the basis of which the joint intention should be inferred.
It occurs to me that where the question arises whether parties to a contract, well, parties to a putative contract had an intention to create legal relations between them, it's conceivable you might find the answer by construing their agreement, but more often you find the answer by looking at the surrounding circumstances, and it's not a matter of construction at all. I mean, I think of a case I had to decide to do with two ladies who were friends going to the bingo together, and
It's got to the Supreme Court.
I think it wasn't in the Supreme Court, and one of them having a big win, and the question was whether something they had said before they went to the bingo was intended to have contractual effect or not, and one didn't find the answer by construing their agreement, but rather in looking at the circumstances. And one can imagine a casual conversation in a pub over a drink, where, again, one might...
That was the Ashley case about whether if the share price hit a certain amount, whether they would give him £15 million or whatever.
And there, again, you don't find the answer as a question of construction, but rather by looking at the surrounding circumstances. That may perhaps be helpful in relation to the contrast being drawn here between a test of affecting the party's intentions in the light of a contract and the surrounding circumstances, and on the other hand, determining it as a matter of the proper construction of a contract.
My Lord, yes. I mean, the short observation, because my Lord hasn't, as it were, asked me a question so much, is they are two very different tasks, the principles governing which are very different. And it is not that the principle governing the present task is unexpressed or opaque. It is stated in subsection 2 on a proper construction of the contract. So that is what makes this a very different scenario to the sort of scenario that my lord was remembering. So at page 1019, at paragraph 7.17, the report defines the effect of what became subsections 11b, 13 and 12 as follows. Second line, in general terms, it establishes a rebuttable presumption in favour of there being a third-party right where a contractual provision purports to confer a benefit on an expressly designated third party. But that presumption is rebutted where, on the proper construction of the contract, parties did not intend to confer a right of enforceability. In our view, the second limb achieves a satisfactory compromise between the aims of effecting the intentions of the contracting parties while not producing an unacceptable degree of uncertainty in the law. It is very similar and would seem to reach the same results as the sole test of enforceability in the New Zealand Act. It may also be said to come close to the Law Revision Committee's proposals that the contract must expressly purport to confer a benefit directly on a third party. That's why I said you might want to remember test 1, because that was test 1. And we say that last sentence is striking, because what the report is saying is that the effect of section 1 as finally drafted comes close to providing for third-party enforceability when the contract expressly purports to confer a benefit directly on a third party, as these contracts did. And what we say is that neither the respondents nor the majority in the Court of Appeal accord proper weight to the rationale for the presumption set up by 11b and 13. If a contract expressly confers a benefit on an identified third party, which is not that common a situation, I'm not saying it's rare or exceptional, but it is a tiny, tiny minority of contracts, then it is sensible to assume an intention that the identified third party can enforce the benefit of the term that the contract provides to confer on him. And that's why the presumption exists, and why it can only be rebutted if the contract provides that the parties do not in fact intend that to be the case. Now, we've trespassed into proper construction of the contract, but strictly I do say that there are two aspects of the language of section 2 which have been misunderstood by the respondents and majority in the Court of Appeal. The first is the words, basically where to put the not, and the fact that it's a rebuttable presumption. What you're looking for is to identify an intention not to confer. The third comes back to these words, on a proper construction of the contract. So Lord Justice Lewis, in his judgment, having set himself the task, quote, to determine whether the parties to the contract intended that a contractual term should be enforceable, which we say is the wrong test, then helpfully at page 267, excuse me, beginning at paragraph 78, sets out extracts from most of the leading cases, including those we've discussed. So ISC and West Bromwich, paragraph 78, the process is the ascertainment of the meaning which the document would convey to a reasonable person having all the background knowledge, etc. So it's the meaning which the document would convey. That's when you are allowed, if that meaning is not obvious, to take account of all the background knowledge, etc. BCC and Ali, in construing this provision, as any other contractual provision, the object of the court is to give effect to what the parties intended. To ascertain the intention of the parties, the court reads the terms of the contract as a whole, giving the words their natural and ordinary meaning in the material context. Sorry. I was going to continue reading, but in the context of the agreement, the parties' relationship, and all the relevant facts surrounding the transactions so far as known to the parties. So they are to give the words their natural and ordinary meaning in that context. So again, if there's any dispute as to the natural or ordinary meaning of the words used, that context becomes potentially determinative, but certainly relevant. To ascertain the parties' intentions, the court does not, of course, inquire into the parties' subjective states of mind, but makes an objective judgment based on the materials identified.
And if, sorry,
go ahead, yes.
Well, if construed in the light of the surrounding circumstances, the court takes the view that the contracting parties did not intend the third party to have enforceable rights, that it would be legitimate. That would be a legitimate approach.
Well, there would have to be something to construe.
The surrounding circumstances, a proper construction of the contract construed in light of the surrounding circumstances.
Yes, but where my lady and I are not entirely yet in agreement, I fear, is there is a critical difference, as all of these cases make clear, between, on the one hand, construing the terms of a contract and for that purpose taking into account all the surrounding circumstances. On the other, construing the surrounding circumstances.
But take the example my Lord Burrows put to you earlier about the chain of contracts. The chain of contracts, none of the contracts would say anything about third-party enforceability, but nonetheless, in its report at page 1020, at Little Roman 3, dealing with presumption, I don't think you came to that section, the Law Commission said, in relation to those contracts, that on the assumption that the deliberately created chain of liability continues to thrive, subsequent to this reform, it wouldn't cut across it because on a proper construction of the contract, in other words, contracts that don't expressly deal with third-party enforceability, construed in the light of the surrounding circumstances, that is, the existence of the connected head contract and the background practice and understanding of the construction industry, the contracting parties didn't intend, etc., etc. And I'm really putting to you, isn't that directly analogous to the situation here? And isn't that what Lord Justice Underhill said was the decisive factor in this case?
Well, to answer the second question first, yes.
Yeah.
To answer the first question as to whether it's analogous, I'm probably, unfortunately, going to end up repeating myself, but I had understood, and obviously you have the Fonz et Origo here to contradict me, but I had understood the chain of contracts scenario to be susceptible to the analysis of the implication of a term. But if I'm wrong about that, then we say that the statutory test as enacted does not go so far as this might otherwise suggest.
But there's the chain of contracts. Would they meet the first two limbs, that they confer a benefit on a third party?
Well, I think the answer is they certainly might, and it's that category which the Law Commission report is considering as opposed to a category where they don't. I think that must be right. So I think we assume for this purpose, although I entirely agree with my lady, it may well not be the case, but we assume for this purpose that there might be a contract in which the subcontractor is undertaking to do something which confers a benefit on the owner, but the owner cannot directly enforce that benefit because the subcontractor's contract with the contractor is part of that chain of contracts. But I'm not going to be able to improve on the answers I've given. Going back, if I may, then to page 268, I think we were on.
as I understand it, you still seem to be setting up, as part of your submission, that there's something about the contract that needs to be ambiguous. And so you don't ever get into the context. That's as I understand it, a part of your submission at least. And what I'm saying to you, I think, or putting to you, is both parties here are disputing the correct construction of the contract. There is a dispute as to whether or not that contract does or does not properly show an intention that the parties shall not confer a third-party right. So we've got a dispute about the construction of the contract.
Well, my lord, calling it a dispute about the construction of the contract doesn't make it a dispute about the construction of the contract. I absolutely accept that the respondents are saying that on a proper construction of the contract, the subsection 2 test is met and therefore there should be no third-party enforceability. That is what they are saying. That is not what they are doing. They are not construing the contract. There is nothing in the contract, just as there was nothing in the contract in the Chudley case or the Nishin case or the Lamthorne Glory case, to construe. So, as Justice Stuart Smith was effectively answering that question when he was reading the draft judgments of Lord Justice Lewis and Lord Justice Underhill, and his answer to them, as you've obviously seen, was effectively my answer to you. That is, there is nothing in the contract on which subsection 2 can bite.
So I think you're drawing a distinction between construing the contract and construing the terms of the contract, one could put it like that. And you say, yes, when you're looking at the terms of the contract, Arnold and Britton et al. Apply in the normal way. But if there are no terms of the contract, express or implied here, then what the Law Commission said the final test was not that you then fall back on construing the contract against its circumstances. What you fall back on is a statutory presumption that where a contract confers a right on a third party, the third party is named, the contract was entered into after the Act came into effect, then there are third-party rights construed.
I agree with the conclusion, my lady, but I would actually, if I may, slightly unpick the premise. It's not that I'm distinguishing construing the contract from construing the terms of the contract. That is what my learned friends are doing. What I am doing is saying construing the contract is to construe the terms of the contract. There is no exercise of contractual construction other than to construe the terms of the contract.
Say, for example, I agree, say Lord Burrows invites me to dinner tomorrow night and I accept his invitation. Or he invites me to go and watch a game of cricket next weekend and I agree to go to the cricket. There is no doubt about what the agreement is. There is no ambiguity. It's absolutely clear. But when you ask, is there an intention that the agreement should be legally enforceable, that's not a question of construction at all.
Exactly.
It's an inference drawn from the surrounding circumstances. Now, there might, on the other hand, be situations where it is a matter of construction of the contract. There might be an express term. Or if there's not, you might nevertheless be able to construe the contract as in a way which throws light on the question of intention. But if it's simply an inference drawn from the surrounding circumstances, then that's not, one might think, an issue of construction at all.
Well, that's certainly what I submit. And I would say, in fact, I will shortly say that in fact, the approach of the majority of the Court of Appeal was absolutely heterodox on the issue of contractual construction. But in order to make that good...
Just going back to the question of implied terms, all this discussion of silence and so on calls to my mind. I think it was Lord Justice Bingham, as he then was in the Philips Electronics case, who says when the contract is silent, that's usually because the parties don't intend there to be a term.
Yes,
Obviously, you can imply under certain circumstances, but the starting point is there's nothing in the contract about it, therefore no term.
Indeed, and because of the factual circumstances here, which we'll go into, it's so obvious, we say, that was the case here. I promise I won't be long, but I feel I ought to go finally, well, not finally, I'll go in this judgment finally to Arnold and Britton, which starts by quoting Chartbrook and Persimmon Holmes. When interpreting a written contract, the court is concerned to identify the intention of the parties by reference to what a reasonable person, having all the relevant knowledge, would have understood them to be using the language in the contract to mean, and then guidance follows.
The important point, if I may interrupt you,
of course,
is that construction, what's implicit in that is that construction is the exercise of ascertaining the meaning of a contract.
That is certainly the way I have always understood it and the way I say all these cases have confirmed. And for completeness, because Lord Justice Underhill refers to it and the respondents also do, can I just quickly go to Wooden Capita, which is at page 896, or the relevant part anyway.
I'm sorry, I didn't hear that.
896, my lady. Paragraph 10. The court's task is to ascertain the objective meaning of the language which the parties have chosen to express their agreement. And then just above F, interpretation is, as Lord Clark stated in the Rainy Sky case, a unitary exercise. Where there are rival meanings, the court can give weight to the implications of rival constructions by reaching a view as to which construction is more consistent with business common sense. And I would accept he could have added, in appropriate cases, the background factual circumstances. But in striking a balance between the indications given by the language and the implications of the competing constructions, etc. So that directly answers the suggestion my Lord Regis made resoundingly in the affirmative. Now, these principles are so well known, they're so often rehearsed, that it does seem possible on the evidence of this case that their central premise, which is the one Lord Reid has just articulated, can be forgotten. Those principles address only the situation where the meaning of the words of written contractual terms, and all right, I won't shudder from the blanket adjective ambiguous, but certainly when there are rival constructions, as it's put, of the objective meaning of the language used. But what they do not do is create an opportunity for courts to construe, in inverted commas, because the word is inapposite, contractual intentions out of thin air, as it were, based not on the terms of the contract, together with any implied terms, but purely on the basis of pre-contractual factual circumstances. Now, it is, or at least it should be, common ground in the present cases. There is no term of the contract which was the subject of rival constructions, and there was and is no suggestion that one should imply a term into those contracts. Moreover, we say in passing, it was also common ground, I believe it's still to be common ground, as Lord Justice Stuart Smith quotes from Harvey on Industrial Relations and Employment Law at paragraph 113 of his judgment, once incorporated into an individual contract of employment. Sorry, I should have given you the page reference. It's 276, paragraph 113. It's a quote from the leading practitioner's work on employment law. Once incorporated into an individual contract of employment, a provision which owes its origin to a collective agreement falls to be construed strictly in accordance with the rules of construction applicable to contracts. So the principles established by Arnold and Britton and Wooden Capita in these other cases, we accept that they might be relevant in another case under the 99 Act where the meaning of written terms was in dispute. In particular, where it was disputed whether the meaning of a contractual term was to exclude third-party enforceability. But those principles are irrelevant in the present case. And I do not shrink from saying that their supposed application by the majority of the Court of Appeal in this case was fundamentally heterodox. Their task was to supplement what the parties to a written contract had included in the terms of their contract in a situation where it was common ground. There was no basis for the implication of other terms. And I would respectfully suggest it could not be put better or more concisely than did Lord Justice Stuart Smith, page 274, at the end of paragraph 106. Suffice to say, 5 lines up, it would be impossible on the facts of these appeals to conclude that any of the legitimate approaches to implication would justify the imposition of an implied term that the rebuttable presumption was included. I interpose, nor was it argued. We are in, he says, the territory of interpreting the language that the parties used, not implying terms to supplement. And that is why we say, going back to page 910, which is part of that article explaining the Law Commission report by Professor Burrows, which my lady has already picked up on, as it were, as neatly summarising the basis on which we bring the first 2 grounds of appeal. So again, picking it up 10 lines through that middle paragraph. Although this was not spelt out in the report, it's my view the presumption is a strong one. I would anticipate, and then for present purposes, it's the following words that are important. It would not be rebutted unless there is a term in the contract expressly negating the third party's legal rights, well, we know there isn't that, or an express term that is otherwise inconsistent with the third party having legal rights, or unless the parties have entered into a chain of contracts which gives the third party a contractual right against another party for breach of the promisor's obligation under the alleged third party contract. So that, we say, and if I'm wrong about the implication dimension to the chain of contracts, then I suppose I...
But what's key there is it's not only a chain of contracts, but it's a chain of contracts under which the third party has a contractual right against someone else.
Exactly.
Whereas here, the union either has a right against the employer or not.
My lady anticipates the submission I was going to make. Yes, and that's why I had thought, Lord Burrows says wrongly, I accept that I was wrong in this, but that's why I thought the business efficacy test, as well as the officious bystander test, would be applicable here, because there is always the right to recover for non-performance by the person further up the chain, and there would be no business efficacy. Well, I won't go there again. If I'm wrong, I'm wrong. But that's why we say, though, that is a separate and defensible category of case that is not analogous to the present case. So it was put more simply, as I suggested in the later article that I quoted from at page 928, where Professor Burrows referred to it being rebuttable as a matter of ordinary contractual interpretation. I've already taken you to that. But at 929, the question is posed, as it were, by himself to himself in the first new paragraph. What material can be used in determining the proper construction of the contract under section 1.2? The idea was the normal objective approach to contractual interpretation should be applied. And we would respectfully say that is what PCS has argued for throughout this litigation. And applying that approach, which is applying the statutory language to the present cases, we say it is, again, impossible to improve on the pithy summary of the conclusion expressed at page 275 by Lord Justice Stuart Smith at paragraph 109. In my judgment, he wrote, the terms of the contract entered into between the employers and employees, as outlined in the judgments below and summarised by Lord Justice Lewis in his judgment, include nothing that indicates a joint intention of the parties that the obligation should not be enforced by PCS. And the expression of that conclusion, as you will see, chimes, not deliberately, I'm sure, with the way in which the same findings were made in several other cases, including the first of the Chekhov cases by Mrs. Justice Elizabeth Lang, as she then was, at page 579 within the Kavanagh case.
Just before we leave it, you jumped over paragraph 108, but that's really, I think, where one finds Lord Justice Stuart Smith's response to the argument that appealed to Lord Justice Underhill.
It is, and we've cited that, and we're going to come back to cite part of it again. But my Lord is absolutely right. If one were to, for PCS, take any part of these three judgments as being the most compelling, it would be paragraph 108 and the first few lines of paragraph 109.
But are you suggesting that the reasoning in para 108, which seems to insulate the individual contract of employment from the collective agreement, is the way that one should be doing this? Because I think Lord Justice Underhill comes back to say that in his view that isn't correct, because the intentions of the employees have to be equated, realistically, with the intentions of the union negotiators, that you can't isolate the two stages in the way that Lord Justice Stuart Smith appears to be doing.
Well,
I mean, you're an experienced employment lawyer, so you know all the debates on this.
I do.
Are you suggesting that the intentions of, objective intentions of the union representatives are irrelevant in construing a contract of employment where the contract of employment has, in a sense, the terms have come from the collective bargain and have been deemed apt?
No, I'm not saying that they are necessarily irrelevant. They may be relevant. They are generally not, but they may be, I accept. But they are relevant, my Lord, only in construing the meaning of the term that has been thus derived. So there are cases where the court has to construe the term of an employment contract. And there are rival constructions. There are many cases, including, I think, cases that have come to this court, including one not so long ago that some of us were involved in debating, where the term is there on a piece of paper, and the question is, what does it mean? What does it provide for? In those cases, it may, depending on the circumstances, be appropriate to say, well, in the context of that having been collectively negotiated, what is it most likely to mean to the reasonable reader, taking into account relevant circumstances? Accept that.
And you would use the union negotiators' intentions as you would treat those as the employees' intentions.
You certainly wouldn't, as it were, try to compartmentalise two different sets of intentions. You would try to ascertain objectively.
Unless there was some reason to do that.
Exactly, exactly, my Lord, yes.
I think you would get into difficulties, though, with pre-negotiation. I mean, what you would be looking at is the terms of the collective agreement and what they say about the terms of the contract of employment, rather than what went on in the negotiations.
Certainly you're not allowed to look at the pre-contractual negotiating positions. That is absolutely clear and orthodox.
But we're not concerned with pre-contractual negotiations here. We're concerned with a statutory background that says collective agreements are not enforceable.
Well, it says they're not enforceable as part of collective agreements between those parties. They say nothing about the enforceability of terms that become...
Oh, no. Yes, of course.
...employment contracts.
Yes.
But to answer, if I may or may not have satisfactorily finished answering the question that Lord Burroughs put to me, but the exercise that Lord Burroughs asks me, is it a legitimate matter to take into account the collective basis of the negotiation of the term? And I said it may well be. Only where the question is, what does the term mean? I know of no case, obviously I exclude the present case, other than the present case, I know of no case.
The term in the contract of employment.
By virtue, in fact, we'll come on to one of the arguments my learned friends raised somewhat obliquely in their written case by reference to cases like AutoCleanse and Uber. But just to be clear, I know of no case where the courts have construed the contract by taking terms or inventing, effecting, constructing terms from the collective process. They can construe the terms that exist in the employment contract, sometimes by reference to that process. That's a different matter.
Sorry, I didn't follow that distinction.
No, nor did I.
Well, I badly expressed them. It comes back to the same point that we've canvassed several times before, which is the distinction between, on the one hand, construing or interpreting the terms of a contract, in which exercise it may be legitimate to take into account the sort of matters that my Lord was suggesting can be taken into account. That's on the one hand. And on the other, effecting an intention that really, as a matter of fact, was unlikely to have existed, based not on the terms of the contract, but only on the pre-contractual surrounding circumstances, in which case I say there is no place for, or there is no special category in that regard of employment contract or collectively negotiated term.
Just to be careful, I'm slightly afraid you may paint yourself into a corner by talking about construction of the terms of a contract as if that's something different from construction of a contract.
I don't mean it to be.
No, because that's the expression used in the statute, of course.
Yes, it's definitely construction of the contract, but and that was a Freudian slip, I suppose, because I keep coming back to the proposition that I will defend until they've burnt all copies of Chitty, which is construing the contract means construing its terms. It does not mean anything more or less.
The difficulty, I think, is that, or a difficulty, is that one has a very unusual question in relation to the 1999 Act, which is whether the parties have intended or not intended to confer legal rights to enforce. In a normal two-party contract, construction would not be directed to that question. You don't have a question of construction in a contract where the legal rights between the parties are obvious, normally speaking. But here, the very question at issue is, have you got legal enforceability by the third party?
Well, I agree. The Act introduces a new concept into domestic law, but if it's not considered too impertinent, I would respectfully reply in the terms that my Lord, writing extrajudicially, put it in that article to which I've now made reference twice, that the statute sets up a presumption which will not be rebutted unless there is a term in the contract expressly negativing the party's legal rights, or a term, an express term, that is otherwise inconsistent with the third party having legal rights. And I would add or an implied term to the same effect.
I mean, I wonder actually whether Lord Burroughs' observation doesn't assist you, because if it be the case that parties don't usually, in contractual negotiations, address the question of enforceability, then I would have thought you say, well, that leaves you with the presumption, and then you get swept into the rest of your argument.
That's exactly what I say, and that's what happened in this case, and it's also what happened in these other cases, which I've probably been too slow to take you to.
Say Lord Burroughs and I enter into a contract under which one of the provisions is that we agree to invite Lord Sales to dinner on Saturday night at 7:30 at Le Savoy.
Yes.
And the question is, did we intend Lord Sales to be able to enforce that provision? I'm inclined to think the answer isn't, the question isn't one of construction of the contract.
Well, the problem with that particular idyllic scenario, though it presupposes, is that it is difficult to conceive of that having legal force at all. So to call it a contract, as it were, impermissibly...
Well, let's assume we actually put in a term that says, and we intend to create legal relations.
Yeah.
Well, all right, let's follow it through. The two of you enter into a contract which begins...
We may have, we may have some business relationship under which, I don't know, hospitality is part of the arrangement.
So you enter into a contract which says, this is designed to have legal effect. I, Lord Reed, will take you, Lord Burroughs, out for dinner, and we will order a very expensive bottle of wine, but we will not drink that wine. We will bring it home, and you will give it, I will pay for it, and you will give it to Lord Sales. And this is supposed to have legal effect. And what happens? On his way home, Lord Burroughs drinks the wine, and Lord Sales never gets it. Is Lord Sales, on that obviously ludicrously hypothetical scenario, entitled to enforce? Why not?
Well, the question I'm asking isn't really is he entitled to enforce it or not, but is the answer to that question arrived at by a process of construction of the contract?
Well, you ask yourself in that situation, is there anything in the contract that you and Lord Burroughs entered into? So you've got an identified third party, the contract purports to confer a benefit on him. Is there anything in that contract to suggest that you did not intend that it should be enforceable by him? I mean, because it so strains credulity, it's difficult really to wrap one's head around it. But on those somewhat incredible facts, no, there is not, and therefore, yes, he is. But,
and you think it's completely irrelevant that the law would normally regard that sort of domestic arrangement as between the contracting parties and the third party? You would say that's completely irrelevant, would you?
On the contrary, I would say that if anything, it confirms the position, because the very fact that in this scenario you have expressly negated the normal position of unenforceability of a domestic contract means that you intend to accord it the status of a quasi-commercial agreement. I mean, it's obviously ludicrous, but let's take a different example.
Well, the only point I was trying to bring out was that one could envisage a situation where there was absolutely no doubt about what the agreement meant, and the only issue is intention to create enforcement, to make the obligation. There's no doubt what the obligation is. The only question is it legally enforceable? And I'm questioning whether that question is one of construction.
Well, according to the statute, I suppose, is the short answer.
Well, the situations where it clearly would be, But in a situation where the meaning of the agreement is clear beyond argument, is the question whether it creates an enforceable obligation a question of construction?
Well, as I say, it is, because the statute says that, I mean, I'm now taking away the double negative. The actual words of the statute are section 1B does not apply if. So let's reverse that. Section 1B does apply if, on a proper construction of the contract, it does not appear that the parties did not intend the term to be enforceable. Well, on a proper construction of that contract, it does not appear that the parties did not intend the term to be enforceable. And I thinking on my feet, take a collective agreement. A collective agreement is presumed unenforceable, but does not have to be. The parties can say it is enforceable. Now, that's quite a good analogue of the situation you've just hypothesized. So you have a category of agreement that is normally not legally enforceable, but the parties are saying right up front, we mean this exceptionally to be enforceable. And then you ask, assuming it were to provide for third-party enforceability, so that we're now talking about an enforceable collective agreement made between a union and an employer, which begins, this is intended, within the meaning of section 179 of the 92 Act, to be an enforceable contract between us. And it has a term which confers a benefit on a third party, by name. And then you ask yourself the question, assuming there's nothing else in the contract about third-party enforceability, is that supposed to be enforceable by the third party? Well, I'm assuming we would all answer yes. And it would be no response to that yes to say, but hold on a minute, most of these types of collective agreements are not enforceable between the parties. So going back, I hope for the last time, with no disrespect to your eating arrangements, to the dinner scenario, if you had really taken the trouble to create a legally enforceable contract that includes the conferring of the benefit of that bottle of wine on Lord Sales, then you are effectively saying construe this like a commercial contract, whatever the normal situation about dinner arrangements may be. Can I just go, I'm close to the time, can I just take you to some of the cases where other judges have considered this provision, starting, if I may, with, I think we were at page 579, or I was about to be, with Mrs. Justice Elizabeth Lang, as she was then, in the Kavanagh case, which was the first case in which the 99 Act issue was litigated in relation to...
Sorry, what was the page here?
579, at paragraph 74. The defendant argued that Section 1.2 operated to disapply Section 1.1b. This, as I understood it, was based on the inherent improbability of an agreement by the defendant that PCS should be able to enforce check-off arrangements, and on a general appeal to the surrounding circumstances. This argument is contrary to the clear words of the statutory provisions and the interpretation given in Nishin. Section 1.2, between G and H, requires me to be satisfied, if I'm to accept the defendant's argument, that on the proper construction of the contract, the parties, not just the defendant, intended that the check-off provision should not be enforceable by PCS. There is simply no contractual material which shows such an intention, whether expressly or by necessary implication. And that decision was not appealed, by the way. So using very similar language, remember, Lord Justice Stewart Smith, that the contracts, terms of the contract include nothing that indicates a joint intention of the parties. And that was not just the meaning of the statutory words on a proper construction of the contract adopted by Mrs. Justice Elizabeth Lang, Mr. Justice Chowdhury and Mr. Justice Friedman, and of course Lord Justice Stewart Smith in these check-off cases. It was also the approach adopted in other cases which have come before the courts. The first is Nishin, page 716. Judgment of Mr. Justice Coleman between D and E, concluding that the statute 1.1b and 1.2 creates a rebuttable presumption such that if the contract is neutral on this question, subsection 2 does not disapply subsection 1b. Whether the contract does express a mutual intention that the third party should not be entitled to enforce the benefit conferred on him, or is merely neutral, is a matter of construction, having regard to all relevant circumstances. Now, the respondents suggest their case is consistent with that approach. It is not. In the present case, the employment contracts are self-evidently neutral on the question. If we go to the Liam Thong Glory, number 2, that was a case, I should just, facts first. So the charterer...
Sorry, where are we?
Well, I'm going to be taking you to page 799, but I was just going to give you a thumbnail sketch of the facts. So the charterer chartered a ship to be carried by the owner to the receiver. So the receiver is going to be the claimant. The contract is going to be between the charterer and the owner. Because the bill of lading relating to the goods didn't reach the receiver, sorry, I've misled myself. Please accept my apologies. Let's start again. The claimant is going to be the ship owner. The bill of lading didn't reach the receiver, and so the receiver issued a letter of indemnity to the charterer amounting to a contract between them so as to receive the goods. And that letter of indemnity, and this is where it becomes relevant to the present case, contained a promise by the receiver to indemnify, be it servants or agents, in respect of liability incurred by the delivery of goods without the bill of lading. The vessel was seized by a bank, which alleged it had the original bills of lading, and the question was, could the ship owner rely on A's promise to indemnify the receiver's promise of indemnity to the charterer?
So was the claimant one of B's servants or agents then?
It was taken to be. So if we go to the relevant paragraph at 799, at paragraph 22, Lord Justice Clark, who's giving the judgment of the court to which the Vice-Chancellor Sir Andrew Morritt and Lord Justice Newberger, as he was then, contributed. Sorry, let me just get the page up. Said this: it is common ground that if the claimant succeeds in showing that the term purports to confer a benefit on him, he is entitled to enforce the term directly against the defendant, unless the defendant persuades the courts that the parties did not intend the term to be enforceable by him. Now, on the question of that intention, the argument for the defendant was that there was a chain of contractual agreements with the claimant having a contract with the charterer pursuant to the charter party such that the statutory presumption was negated. So that was the argument between the parties. And at 809, at paragraph 54, this is the way that is addressed, starting just above B. All depends upon the construction of the receiver's LOI. And then, having noted that the indemnity was intended for the benefit of the ship owner, they find, in similar words to those used by Lord Justice Stuart Smith in the present case, there was, just at C, nothing in the LOI to lead to the conclusion that the parties did not intend the indemnity to be enforceable by the owners, which was the end of the matter. Sorry, what? The purpose... well, so I'm conscious of the time. Can my learner friend pick up this when he's responding? Thank you. In Chudley, B entered into a contract with a bank requiring the bank to open a separate segregated account for a specific development from which monies were not to be removed unless certain conditions were met. The claimants, various investors, paid money towards the scheme, but the bank placed their money into its general account, didn't set up a segregated account. B went into liquidation, and the bank released the claimant's money. The claimants subsequently became aware of that instruction, contract between the bank and B, and sued under the 99 Act, and their claim was upheld. At page 602, Lord Justice Flo is directly addressing a different point, which is whether the same contractual term can both identify the relevant third party and confer a benefit on him, which he finds obviously to be so. Picking it up between G and H, suppose that the LOI had referred in the opening provision to the bank opening an account named ARC LLP, Segregated Client Account for Chudley and Bean monies. Chudley and Bean were the claimants. That would clearly be express identification of the claimants for the purposes of section 1.3. Any suggestion the same provision did not purport to confer a benefit on the claimants would be patently absurd. Note, though, he goes on to consider that it's equally obvious that the bank would never be able to establish under section 1.2 that on a proper construction of the LOI, the parties did not intend the term to be enforceable by the claimants. And then at page 604, beginning at paragraph 90, Lord Justice Longmore considers the meaning in effect of subsection 2 more directly. He describes that just below D as a carefully calibrated provision. He cites that paragraph 7.17, to which I've already taken the court from the Law Commission report, but then also quotes 7.18, just above E, which we cite in our case and which is in the report if you wanted to see it there at page 1020. The presumption of enforceability is rebutted where the proper objective construction of the contract is that the parties did not intend the third party to have the right enforceability. This is where, and only where, the onus of proof comes in. The onus of proof will be on the contracting parties, usually the promissor, so that doubts as to intentions will be resolved in the third party's favour. A promissor who wishes to put the position beyond doubt can exclude any liability that he might otherwise have had. And having quoted that, at paragraph 92, Lord Justice Longmore notes that whereas the recommendation could have been that a party could only enforce a term conferring a benefit upon him if the contract gave him an express right to do so, the ultimate conclusion was that it was not necessary, that it was not necessary, and that if the promissor wished to exclude that right, he could always do so, and proceeded to find in similar terms, again to those used by Lord Justice Clark and by Lord Justice Stuart Smith in the present case, there is nothing in the PB LOI which indicates that the investors of the Paradise Beach scheme should not be allowed to enforce the term requiring money to be paid against the OM undertaking. And trespassing just a minute or two, if I may, into the short adjournment time to finish with Chudley. As Professor Davis commented in his 2021 article in Law Quarterly Review about this case, it's at 954. First new paragraph on that page. Did giving the investors a right to enforce the contract reflect the intentions of ARC and the bank? This seems most unlikely. It is improbable that the bank intended to expose itself to claims brought by parties it didn't know and to whom it had made no promise. And it's just as unlikely that ARC intended to confer enforceable rights against the bank upon the investors. And we would respectfully agree. I can't believe that would be disputed. So even where it is possible safely to infer from the background facts that neither contracting party intended to give the third party a right of enforcement, that right of enforcement will still exist pursuant to Section 1 of the Act if there is, and I'll use the words that all these different judges have used, nothing in the contract to negate it. And, of course, if the term in question confers a benefit on an identified third party. And finally, finishing with this case law, we do say it's unfortunate, and Professor Davis himself points this out, that the majority in the Court of Appeal didn't address any of it in their judgments, and they were referred by the parties to it. And it's particularly surprising as regards Chudley, because that was relied on in two parts of Lord Justice Stuart Smith's judgment, which was obviously considered by the other two members of that court. Anyway, we say it is not possible to reconcile the approach the majority adopted to subsection 2 with the approach adopted by the courts in those earlier cases. And indeed, if one did, you would end up with that unacceptable uncertainty that the statute was designed to avoid.
Oh. Have we completed Chudley?
I've completed the case law. Thank you, my Lord, for allowing me to do that.
Not at all. Very well then. We'll adjourn and resume at 2 o'clock.
Thank you.